and we have to really escalate the noise we make so that we'll be heard.
Where are we? Welcome to Gay USA. I'm Andy Hum, equal citizen of the United States of America.
I'm Ann Northrup, but I'm taken by the fact that the last shot in that opening is so relevant today because it's a female couple in California celebrating getting married a few years ago.
If you've been hiding under a rock and are dependent on us for your news, we won.
Poor you.
The Defense of Marriage Act has been struck down by the Supreme Court, and the Prop 8 case has been dismissed for standing. Therefore, same-sex couples are going to be able to get married in California. Here to digest all of this with us is our distinguished panel of experts. Professor Art Leonard, who teaches at the New York Law School and writes for the Gay City News and does his own law blog and has been writing about this forever. And Professor Larry Levine, who is a professor of sexual orientation law at the McGeorge School of Law in Sacramento, California, and was a witness to both of these cases in the Supreme Court. Welcome.
Thank you.
And we are taping this on Wednesday afternoon, just a few hours after the decisions were released, the beauty of that being the freshness of all this in our minds. But also, Andy and I have not had the pleasure of reading through all the opinions as you two have, so we get to be semi-ignorant questioners, getting you to lay all this out for us. So let us start with the DOMA case, because that's the big sweeping overarching opinion, I think. 5-4 by Justice Kennedy, who's developing quite an historical niche for himself as the author of the Lawrence v. Texas, Romer v. Evans, and now U.S. versus Windsor cases, joined by the conventional crowd of liberals, Sotomayor, Kagan, Breyer. Who am I leaving it?
Ginsburg.
Thank you.
Don't forget her. She's been dissenting like crazy all week.
Exactly, and opposed by Robert Scalia, Thomas, and Alito. So, tell us what this decision says and what's this all about?
Well, this decision, and it's sort of curious that for once, everybody who was making predictions the last few days turned out to be correct. Mm-hmm. I mean, everyone was saying Kennedy will write it. It'll be a decision on the merits, but we're not sure what theory he'll use, and he'll strike down Section 3 of DOMA, and that on Prop 8, Chief Justice Roberts will write it, and it'll be on standing. That's what everyone was saying, and everyone turned out to be right for a change. Section 3 of DOMA, enacted in 1996 in the wake of hysteria and panic about the possibility of same-sex marriage in Hawaii.
Right.
Which never
came about, but is going to sometime soon.
Yes.
In a state near you, there will be same-sex marriage. So DOMA was passed then, and Section 3 of DOMA says that the federal government will only recognize different-sex marriages, not same-sex marriages. When the word marriage is used in federal law, it means different-sex marriage. When the word spouse is used, it means a spouse of the opposite sex.
And what continues in the Defense of Marriage Act is that states still can do it, but they don't have to recognize legal same-sex marriages from other states, and they don't have to do them themselves.
Well, let's not get ahead of ourselves.
That's Section 2,
yeah.
and we'll just quickly mention that because that's not involved in this case. Yeah. Section 2 says that no state is required to give full faith and credit to same-sex marriages contracted in other states.
And this decision is not about legalizing same-sex marriage. It's about...
Well, let's stop before we say, you know, one of the problems with doing this just a few hours after the opinion comes out is we have not had time for mature reflection yet. We are doing reflex reactions at this point.
Mature as we
In fact,
may be.
I saw one email that popped up on my inbox said, Supreme Court declares Prop 8 unconstitutional. Where did that come from? You know, so people jump to conclusions and they oversimplify.
Right.
So we're trying in the excitement of a 77-page decision on DOMA and a 33-page decision on Prop 8 to boil it down and figure out what it means in the short run.
You would.
So,
I feel like I'm cross-examining. I feel like I'm going to cross-examine you, but you would concede, wouldn't you, sir, that the court did not say that all states have to let gay people marry now, correct? They
Well,
clearly
right.
say they
I
don't.
suspect a lot of the public will
Here's
misunderstand
the story.
this as that.
Here's the story. There are 4 opinions in this case. There is an opinion for the court by Justice Kennedy, which is signed on by the 4 Democratic appointees who you mentioned. There is a dissenting opinion by Chief Justice Roberts. There is a dissenting opinion by Justice Antonin Scalia, which is joined in part by Chief Justice Roberts and in its entirety by Justice Thomas. There's another dissenting opinion by Justice Sam Alito, which is joined in full by Thomas. And Thomas is being very inconsistent because there are distinctions between Scalia's opinion and Alito's opinion, and Thomas is joining both.
Well, he's consistent that if it's against gays and lesbians,
Yeah.
he's on that
Yeah,
side,
I'll
basically,
resist
right?
making a lot worse statements
Yeah,
about
but so at any rate, what Chief Justice Roberts in his dissent and Justice Scalia in his dissent make very clear is that they are worried about the impact that Justice Kennedy's opinion might have on pending lawsuits for same-sex marriage in places like Hawaii and Nevada and New Jersey and Illinois, and now I think there may be a few others. New Mexico, there's a lawsuit. So they're concerned. So Justice Kennedy says we don't have to decide the question of whether same-sex couples can marry. That's not before us. That's a 14th Amendment question. We are concerned with the 5th Amendment of the Bill of Rights, which is binding on the federal government, and whether that's violated by DOMA.
And explain what the Fifth Amendment
The
says,
Fifth
because most
Amendment
people think of
says-
the Fifth
the
Amendment,
Fifth-
I don't have
yeah,
to testify against
well,
myself.
But among other things, it says that no person shall be deprived of life, liberty, or property without due process of law. And the Supreme Court has held in decisions going back now a century or more that there is a substantive component of that. Even though due process sounds like a procedural protection, there's a substantive component that means that the government has to have a legitimate reason for taking away your life, liberty, or your property.
And in the case of Edie Windsor, $363,000 extra in taxes.
But
which
it's more
was an
liberty. The issue there, Justice Kennedy says that the right to have your state law marriage recognized by the federal government is an aspect of liberty protected by the Fifth Amendment.
And
in addition,
and this is interpreted as equal protection. Is that how we get to that?
In addition, the Supreme Court has said that the guarantee of due process would be pretty meaningless if it did not incorporate a requirement of equal treatment for similarly situated people. So the court has read into the Fifth Amendment an equal protection requirement that it says is exactly the same as the equal protection requirement under the 14th Amendment, which is binding on state governments.
Okay.
It's complicated.
Now,
this is why law students struggle through con law.
Larry, he uses the phrase, in quotes, careful consideration standard. A careful I hadn't heard this before. We've heard of heightened scrutiny, strict scrutiny, all these kinds of things. What does the careful consideration standard mean?
Well, I don't think you're alone in having never heard of it. It's a new standard, I think,
No, it
as
isn't.
of today.
It isn't. You know why?
Why not?
Because it's in quotes. He quotes from another case.
Okay, let me try another way.
And you know what case he quotes from?
Tell
Romer versus Evans. He quotes himself where he used the word, the same phrase,
Yeah.
and he said, when a state enactment takes away rights from a specific group of people, we have to give careful consideration.
When you're disfavoring a
Yeah.
group. But some have called this rational basis with a bite or rational basis plus.
Right.
He doesn't use those terms.
I like the
He's-
dental term, rational basis with teeth.
With teeth, right. So there's this somewhat mysterious standard, and he does get maybe appropriately some criticism in the dissent, saying, what is this thing you're making up here,
Well,
this new standard?
but, you know, why not make something up? And I assume this is somewhere between rational basis, which rational basis review means that if you can come up with any explanation that isn't from Mars, you can let a law stand.
Correct.
And the bigots, to use a legal term, would say that they have plenty of reasons that we should be kept out of marriage, and they've trotted them all out. And if the court agreed with them, that would be a rational basis review. Heightened scrutiny would require better reasons, and strict scrutiny would require really
Compelling
good reasons.
reasons.
And careful consideration is somewhere between rational basis and heightened scrutiny.
Or maybe another way to look at it is rational basis when it deals with treating people differently has an extra oomph, and there's this concern that he's articulated many times, Justice Kennedy, including today, which is that you just can't, if animus is all you got,
Right.
that's not good enough.
All right.
Well,
So-
I think that's in fact an analysis that says we're not even going to, we are dismissing their reasons, but we don't even have to go too far with that as long as we can see that their real reason is hatred, is animus. And that is really not legitimate.
It doesn't even have to be hatred. I mean, the point that Kennedy makes, I mean, he mentions due process liberty, he mentions equal protection, he also mentions federalism. And he goes to develop the history of state dominion over the issue of marriage. That traditionally in the United States we have a division of authority between federal and state government. Certain things are considered quintessentially matters of state law, and one is marriage. We don't have federal marriage licenses in this country. Prior to DOMA, we never had a universal federal definition of marriage.
Right.
We had a definition of marriage in certain statutes. Marriage is defined in particular ways because of particular policy concerns of the statute as to who's married. But generally, the United States Code lacked a general definition of marriage until DOMA was passed. So he says, you know, our tradition is states decide who gets married, and the federal government respects those marriages unless there is a very, very good policy reason for not respecting certain marriages.
And a lot of people watching this show, and most people are going to want to know what rights same-sex legally married couples are going to have, or possibly still not have in some cases if they move around the country. But
Right.
before we leave the issue
But
of...
we still haven't gotten to Kennedy's rationale, because he had a
Right.
third rationale,
Yes.
and I want to
Well-
bring this to his fruition, and that's
Please.
federalism. He says federalism is an issue here too, and according to Chief Justice Roberts in his dissent, the main theme of the majority opinion is federalism. And the reason he said that is to try to signal to lower courts that they shouldn't rely on this decision in pending lawsuits seeking same-sex marriage.
But I would think Roberts would
Because-
support federalism.
Well, he is in favor of federalism.
So what
Very
is,
much so.
not having read his dissent yet,
Yes.
or any of the others, what do the dissents say? What is their argument against the decision?
All right. Roberts and Scalia both say that the case shouldn't have been before the court.
Oh, it's
They
a
both-
standing question.
Well, it's not really standing. It's a jurisdictional question. They say when we had two formal parties to the case when it was filed, the United States of America was the defendant, as represented by the Justice Department, and Edie Windsor was the plaintiff. The trial court was given a motion to dismiss by the federal government. The federal government's motion said, please don't dismiss this case, rule in favor of Ms. Windsor.
Yes.
You know, and Scalia says in his dissent, oh, that's bizarre. You know, so the case goes to the Second Circuit because the Justice Department filed an appeal. And they say to the Second Circuit, please affirm the district court, but on the theory we're proposing. And the Second Circuit affirmed the district court on the theory that the Justice Department was proposing.
Even though we're
scrutiny.
defending DOMA.
Even,
Right.
well,
That
but by then
was-
BLAG is
Technically.
involved,
Technically.
you know. And then the Justice Department petitions the Supreme Court and says, please take this case so you can affirm the decision below. So Roberts says, you know, this is kind of bizarre. Never in our history have we said that the federal government can win a case below and then appeal it and ask us to affirm the lower court's decision. He said, where is the controversy? Where is the adverse parties? You know, we're only supposed to decide real cases between adverse parties, and we think the only parties in this case are Edie Windsor and the Justice Department, and they're not adverse parties. So he says, we shouldn't be deciding this case. And Scalia says it, you know, in much more colorful language, but basically the same thing. We shouldn't be deciding this case. It's not properly
And it's not
before us.
preposterous either. It's not
No.
a preposterous.
It's not a
We're one
preposterous
vote away
argument.
No.
from that being the resolution, which would have
Well,
created
not
chaos.
quite, because Alito doesn't agree.
Well,
Alito's dissent
If you
says,
would have if you had
Alito's
this option.
dissent says, this case is properly before us because the bipartisan legal advisory group of the House, BLAG, which was allowed to intervene to defend DOMA, was in the case, and they presented the adverse party, and it's a real dispute, and, you know, Edie Windsor doesn't get paid unless we rule on this case because the federal government's refusing to comply with the lower court's decision. So he says this is a real controversy. So
Right,
let's get to
because
the merits, says
President
Alito.
Obama wasn't defending the Defense of Marriage Act, but he
Right.
was enforcing it.
He was enforcing it.
in fact, the
So-
Chief Justice actually, in oral argument, I think unnecessarily was sort of attacked the president for being spineless. And I actually think what the president was doing was presenting this controversy and allowing the courts to to do what the courts are supposed to do.
Right.
And the Chief Justice was very critical of the president for not having the spine and backbone to stick to his convictions, which
Yeah, I
seemed very
found that a little
peculiar.
shocking.
A little shocking.
So in
wasn't
terms
it?
of the dissents, the Chief Justice very briefly says he agrees that DOMA is constitutional, but he focuses most of his opinion on the standing thing. Scalia does the standing thing, and then he has this lengthy diatribe against Kennedy's opinion on the merits, which basically, if the court didn't have standing and there's no jurisdiction, he shouldn't have even talked about the merits. But he goes
can't
on
help
at great
himself.
length. He can't help himself. And in fact, this is my favorite part, as I was telling you both before we started taping the broadcast. There's a page in Scalia's opinion which is devoted to taking excerpts from Kennedy's opinion and editing them as they would appear in a state court opinion striking down a state DOMA.
He also talks
really fun.
about this decision coming out of a diseased root,
Yes.
an exalted notion of the role of this court in American democratic society.
And
Right.
he says that Kennedy has declared us, quote, enemies of the human race, meaning
Right.
the antis.
Yeah.
Yeah, well, he is.
could agree with that.
He is very harsh on the idea that people who supported DOMA are bigots. He says they're not bigots, they were very practical people. They saw a looming problem that there would be different definitions of marriage in different states. They wanted one definition for all federal law.
There are different definitions of marriage for
Right.
heterosexuals
Already.
across the
Already.
country.
And Kennedy points up the specific examples.
I smell us going right back to slavery.
Yeah.
Well,
Justice Thomas says we will if the Voting Rights Act isn't struck down, and so thank God we struck
Well,
down.
and we should say, even though we're caught up in the victory on DOMA, the voting rights decision was horrendous and
The affirmative action
bigoted.
decision is problematical.
Affirmative, and the decision in the anti-discrimination case, which makes it harder for people to bring complaints of discrimination. So
Right.
even if we pass the Employment Non-Discrimination Act, it's going to be harder to bring cases.
In other words, that's going to have to be rewritten slightly, the current bill for the Employment Non-Discrimination Act, to take account of Monday's 2 Title VII decisions.
I
And
think
yet, the,
But getting back to DOMA, so,
Okay.
you know, the big issue for us, number one, is what happens next in terms of federal rights.
right.
First, there is a waiting period before the court's decision goes into effect because the losing party has an opportunity to file a petition for rehearing.
Are they
So
going to?
The federal government isn't going to file a petition for rehearing. Will BLAG, maybe.
And it very rarely is,
Yeah.
very rarely is allowed.
Windsor's not going to file. She won. So after 25 days, the mandate goes out, the decision goes into effect, and that means, for all purposes of federal law, legally married same-sex couples have to be treated the same as legally married different-sex couples. But this is the big question, and Kennedy's opinion is, I think, deliberately obscure on the point. What about same-sex couples who marry in New York and move to Pennsylvania, and Pennsylvania doesn't recognize same-sex marriage?
Right.
Does the federal government have to recognize if they live in a state that doesn't recognize?
Well-
And Kennedy's opinion does not answer this
Well,
question.
what we learned is that
Yeah.
some parts of the federal government already are okay with that, and others are
Right.
not.
For some federal statutes, they ask, was the marriage valid where it was contracted?
Right.
For others, they normally ask, is the marriage recognized where they're living?
Right.
Right.
So the President and the Attorney General are putting their heads together. The White House issued a statement right after the opinion came out, applauding the opinion. And the President said he's directed the Attorney General to get together with all the cabinet heads and figure out what they have to do to smoothly implement this policy of recognizing same-sex marriages.
But that doesn't make a statement about whether
No.
they're going to
They have
issue
to
like
decide
an
how to do
executive
this.
order to
Right.
change the policies of a particular department.
The
And we can say what they
ideal-
are. You know,
Social Security.
Social Security will not recognize it if you live in a state where it's not recognized. The Defense Department will.
And Chuck Hagel, Secretary of Defense, has already issued a statement saying his people are getting to work on changing all the rules of the defense so that now families will get benefits on an equal basis, and all of that will be straightened out.
The issue that Art brought up, because I think some of the viewers might wonder, well, what is the alleged justification for supporting the Defense of Marriage Act? Because it seems at first blush a really easy case, and,
Right.
and one or two of us might have a little bias on this, when the issue is, here you've got two sets of legally married couples, can you treat them differently? Your immediate reaction, of course not, right?
Right.
How could you possibly justify that? And at the end of the day, it's a 5-4 ruling. So it's a closer call than we might immediately think.
Yeah, well-
and hold on, one of the points is that there was an argument for uniformity. And the issue to support that is the issue that I brought up, is that one way around that issue of how do you deal with these marriages when people move is you just don't recognize them anywhere, and then for federal benefits.
That was Paul Clements, the lawyer for the House Republicans. That was his main argument.
Who did a wonderful job. I mean,
He's lost every case.
Well, let me put it this way.
He wins a few, too.
He was such a good
On this?
advocate.
Yeah.
He almost had you persuaded.
I sat there thinking, oh my God, maybe this isn't. I really, he was that. But I mean, for a minute only. But he was really. I mean, he didn't have a law to support him. That was his, a real problem, right? There was, how do you justify this unequal treatment of married couples? So he had that little problem that he had to contend with, but he did as masterful a job as one could, I think, in front of the court.
I will take back my immediate statement because Andy and I went to the arguments in the appeals court here on the Windsor case and heard him versus Robbie Kaplan, and I had the same reaction you did.
It's scary,
He's
right?
very
They lose
smooth.
this.
He's very smooth. He's
very
very
smooth.
calm in
And
front of the.
we keep talking about Edie Windsor. Put her picture up there with
Yes.
Thea Spire, her late
Yeah.
partner, her late wife, who they only got married 2 years before Thea died. They got married in Canada. We should pay tribute to the grassroots activists who helped them get up to Canada
There they
and
are.
get married. Brendan
Edie on the
Fay
right.
and his civil marriage trial. There's Edie on the right. And Edie was just brilliant at the press conference today. We're sorry we
God,
don't have
yes.
footage. We'll bring some in next week.
Everyone will have seen it by now.
They asked her a lot of questions, and and she just was she was just brilliant.
Well, she said a couple of things I think we should quote.
Yes.
Your favorite.
Well, I mean, they asked her about her past life, and that she's so late to the game in terms of activism, and she said, I was self-hating. She said, internalized homophobia is a bitch. I don't like that word, but with coming from Edie, it was quite charming.
Edie's entitled. She
Yes.
just turned 84.
and let's
what-
hope that she gets her tax refund because she's got to wait a little longer.
Yes. What I liked that she said was people asked about where do we go from here or what does this ruling mean? And she was so eloquent about the fact, and I think so because I buy into this theory, that this isn't just about marriage per se. It is about the dignity of us as human beings. And it's about ending stigma. It's about ending suicides. It's about self-respect.
She said people have to come to see us as human beings who live and love like they do.
Well, I hear from so many people, why do we have to focus on marriage? Why do we have to put all our resources there? And what I try to explain to them is this is the marker. This is the vehicle currently. It is because people made it so. But the whole point of this is to establish us as equal human beings instead of second-class citizens. And people should be grateful for the fact that this path has been established. And it has much larger applications. And I was at a lesbian golf tournament last week.
No way, a lesbian golf? I didn't know they had such
redundant,
a thing. Yeah,
right?
really, exactly.
And someone made these little shirts that go from 1969 Stonewall to 2013 Supreme Court. They were anticipating the decision with a cute little thank you, Edie, on the back of the T-shirt. Isn't that nice?
And Edie said, if I had to survive Thea, what a glorious way to do it.
Yeah.
It was really
That's
touching.
great.
I mean,
She was great.
Right. So the bottom line on this, because we really
Yes.
should turn to Prop 8.
Yes.
We should.
is that people are going to be eager to hear about that one. So the bottom line on this is the Obama administration has to get their act together
Yep.
to get the word out throughout the federal bureaucracy that we're going to smoothly implement this and we're going to recognize same-sex couples.
but we don't have answers to
But we
some
don't
of these
have answers to all the
questions for
questions. And
people.
Scalia devoted a part of his dissent to the failure of the majority to deal with this important question.
And not only does the federal government have to get its act together on this, but this can be used, this rationale, I think, to now start attacking the state constitutional amendments against same-sex marriage.
In other words, you agree with Scalia that
Yeah,
this opinion
I agreed
opens
with him
up
10 years
right.
ago.
This opinion, and I agree with him too.
I
think
think DOMA was always unconstitutional. I think all these state constitutional amendments are unconstitutional, and I think they will all just like little dominoes.
Well, I think
fall.
I got this from Art Leonard, but I mean, when they were you were there when they were arguing the case, and it was Scalia who said, "When did it become unconstitutional to deny homosexuals the right to marry?" And Olson did not have a good answer, but it should have been when you wrote your dissent in the
Lawrence.
sodomy
Like
case,
10 years ago.
and said this is going to lead to homosexual marriage. There's nothing in the way of it now.
Absolutely.
Yeah.
In fact, I have, well, there's two things. One is to the day, this is the 10th anniversary of Lawrence. So I think that's quite meaningful. And Justice Kennedy, writing both, has really made his mark. And after Lawrence, I have said, with some just, but only some, that the only sure vote we have on the Supreme Court in favor of marriage equality is Justice Scalia.
Exactly.
And he's the one who's on record saying, and he just reiterated it.
Except he doesn't
Today.
feel himself bound by prior decisions of the court
He's
from
a
which he
hypocrite.
dissented.
He's a hypocrite. Oh, and by the way, the American Family Association says God will now punish us for all of this. And
Well,
we've lost his
wait a minute. The
protection.
decision was this morning. We managed to get up here without being struck by lightning, so I think we're all right.
Yeah, but the weather report is not so good for this
Yeah.
afternoon, so be careful leaving.
And we're happy that President Obama called Edie Windsor from Air Force One on his way to Africa.
And also called the Prop 8 plaintiffs, so we should talk about that
let's use that
too.
as a segue, yes.
Right.
Let's move on to Prop 8.
So-
So Prop 8 was, in 2008, the Supreme Court of California declared a right of same-sex couples to marry as an equal protection reading of the state constitution in California.
And due process, both.
And due process. And then the right wing went out and got a referendum on the ballot. Proposition 8.
After 18,000 couples married.
After
there was a
18,000
sitting room.
couples
And they're still married.
And they're
Yeah.
still married.
But put
Many
a
of them.
question on the ballot.
Some of them are divorced.
Yes, exactly. Some of them just disappeared, I'm
Yes.
sure. Put a question on the ballot to the voters about changing the state constitution to outlaw same-sex marriage. Voters, in their infinite wisdom, passed this proposition, and then this long legal battle ensued. In fact, prompted by Chad Griffin and the American Foundation for Equal Rights and Olson and Boyce, to the consternation of the traditional LGBT legal groups who
Which
thought,
are breathing
oh, no.
a big sigh of relief today.
Oh my God, yes.
But, you know, I think one point to make about the case before we get into the actual
go ahead.
holding is that a lawsuit is not just about the lawsuit. The lawsuit is about the effect on the society of bringing the suit and the publicity surrounding it and the publicity surrounding the trial, the reenactments of the trial on YouTube, then the play that, you know, this has all affected society.
Yes.
If you look at public opinion polls at the time of the Prop 8 vote and at the time of the trial and today, you just see that, you know, there's so many factors that bear on public opinion, but I have to think that this litigation has had an impact.
Ted
on
Olson,
public
one of the most
opinion.
conservative lawyers in the country, bringing the case on our behalf with David Boyce, but, you know, certainly had an impact.
And getting a lot of high-powered gay Republicans in with AFER, you know, with the funding and everything
Yep.
else. So, so at any rate, they filed the suit over the protests of the gay rights groups. The gay rights groups wanted to intervene, and they said no, and the judge agreed with them. Keep the gay rights groups out. They can be amicus curiae, but they can't participate in the case.
The AFER press release today
Yeah.
said AFER, the sole sponsor of the lawsuit.
Right, so then there's this big trial before Vaughn Walker, the closeted federal district judge in San Francisco who didn't come out until he retired after the case was
Right.
over. You know, so some people will say this case was rigged, but
They tried
I
that.
think a lot of people have tried to say that. But at any rate, he held lengthy hearings, lots of witnesses, produced a 100-plus page opinion full of detailed factual findings.
Although the other side did not provide
Two extra witnesses, one of whom has recanted his testimony at this point.
Because they said everyone's too scared to testify
Right.
because they'll be
They'll be blackballed in the profession,
Yeah,
et cetera,
yeah,
because
whatever.
after all, what they'd be saying would be garbage. But under oath, too. So Justice Walker issued his opinion holding that Prop 8 violated the 14th Amendment, equal protection and due process rights of Californians. And he issued an order against the governor, the attorney general, the head of the health department, and the county clerks in Alameda and Los Angeles counties who had turned down the plaintiffs for marriage licenses, saying that Prop 8 may not be enforced and that the governor and any people under their supervision are not to enforce Prop 8.
And this is Governor Schwarzenegger at the
This
time.
is Schwarzenegger. Jerry
and-
Brown was the attorney general.
And he doesn't appeal.
He doesn't appeal. Brown doesn't want to
Well,
appeal.
I mean, Schwarzenegger didn't appeal.
Right.
Right?
None of the defendants wanted to appeal. They were perfectly happy to comply with the decision. But
Even though Schwarzenegger had vetoed marriage bills passed by the legislature
Right.
twice.
Well, he vetoed them because he said the matter is before the courts.
As
And so then the
peculiar as that
California
is,
Supreme
yes.
Court decided the case.
That was,
Yes,
that
but
was
so.
But the point is that
Disingenuous
at the
at
trial, none of the defendants wanted to defend Prop 8. So the people who initiated it, it was a ballot measure. The proponents of the initiative petitioned for the right to be defendants in the case and defend Prop 8, and Judge Walker allowed them to, so there'd be a real case of controversy. So they
So he
hired
allowed them
attorneys.
in.
He allowed them in. Their attorneys put up a valiant fight. They lost. Then they wanted to appeal the case to the Ninth Circuit. And the attorneys for AFER said, well, hold on a minute. How can you appeal the case? You don't have standing to appeal the case. Judge Walker said, well, I doubt that they have standing either. The Ninth Circuit said, well, we're not sure if they have standing. Let's ask the California Supreme Court. So they asked the California Supreme Court if initiative proponents have standing to defend their proposition if it's challenged in court. And the California Supreme Court said yes. They have representative standing. They're representatives of the people of California who enacted the proposition. So on that basis, the Ninth Circuit said they have standing, we'll decide the case on the merits. And the Ninth Circuit decided that it violates equal protection for the people of a state to vote to amend their constitution to take away a right that people already have.
It was a more limited decision than Judge Walker's
It was just a
decision.
California-focused decision. So then the proponents petitioned the Supreme Court for review.
And we're kind of hoping that the Supreme Court doesn't take the case. And then what we reason is that probably the 4 conservative justices, to slow the process down, and they don't like the fact that this group was given standing, they take the case.
But we don't know who voted for cert. They don't.
No.
They don't announce that. So
I suspected that they took the case because they were interested in the question of standing, because they had some disparate opinions in lower courts or from them or whatever.
yeah, for whatever reason, they took the case.
Well, one thing we do know is that in oral argument, Justice Kennedy raised the idea that maybe we should never have heard this case.
Yeah.
And Justice Scalia angrily said, well, it's too late now, which is not really true. But
Yes.
And so you're pretty clear, at least where a couple of the justices were on this, but it's true
yeah,
that.
Scalia didn't want to take it.
But I was devastated when they when they took the case, when they granted cert, the Prop 8 case. I was surprised and really, really sad.
Because it would have allowed the lower court ruling to stand. But where are we now on
Where
they
are we
hadn't
now?
taken
All right. On
Yeah.
behalf of himself and a sort of odd crew,
Very.
Scalia, Ginsburg, Breyer, and Kagan, Chief Justice Roberts says that the proponents did not have standing, that we have never recognized standing on the part of private citizens to represent a state, that the only people who can represent a state in defending a state statute or constitutional amendment are state officials, elected officials or appointed officials, accountable, politically accountable state officials. No one else has standing to represent a state because the only interest the proponents have, once Prop 8 was passed, the only interest they have is the same interest as every other citizen in California as to whether it's constitutional or not, and we've never had that to be adequate for
So
standing.
let me start with the majority. Is that all any of them
They said
focused
nothing on the
on?
merits, nothing on the merits. And then the dissent by Kennedy, who says they do have standing. He says the California Supreme Court says they have standing as a matter of California law to represent the people of California. And a state should be able to designate who represents its interests in court. Here it isn't the governor who's designated them or the attorney general or even the legislature, it's the state constitution, because the Supreme Court interpreted the state constitution to give them that representative standing. So Kennedy goes on and on about how they do have standing. He never discusses the merits either.
And-
Neither opinion discusses the merits. And his partners on this dissent were Thomas Alito and Sotomayor.
No, Sotomayor or Kennedy.
Kennedy dissent joined by Thomas Alito and Sotomayor.
Oh, okay. Yes, sorry. I got
Another odd
confused.
grouping.
They're all
So-
confusing me.
So what's the upshot? The upshot is that the case is remanded to the Ninth Circuit with directions to dismiss the appeal for lack of jurisdiction because it wasn't brought by a party with standing, which means that the stay of Judge Walker's order, which was imposed by the Ninth Circuit, will be lifted.
And
When?
the district court decision will go into effect. But why isn't the district court decision affected by the fact that these people didn't have standing? How do they have
Because
standing at the district court
They
and
don't
not
have
at
to
the
have
Ninth
standing.
Circuit?
The only party who has to have standing at the trial level is the plaintiff. At the appellate level, the only party who has to have standing is the appellant. At the Supreme Court,
the
the only
people
party
who
who has
brought
to
the
have standing is
lawsuit
the
are saying
petitioner.
they were
Oh,
injured, right?
It's the
They're being
moving party. The
It
party is
changed.
bringing
Yeah,
the
I
action.
got it.
They're being
Okay.
deprived the right to
So
marry.
there
that
is
was
no
their
doubt.
injury.
In fact, Roberts goes into this in his opinion. He says there's no doubt that the district court had jurisdiction in this case, that the plaintiffs had standing. They applied
Okay.
for marriage licenses. They were turned down.
Right.
They had an individualized
So
interest.
they're the ones.
So
with the
that
standing.
means that the trial court's decision stands as an unappealed trial court decision. Now, you asked when. 25 days after today, the time for filing petitions for rehearing will expire. The court will send its mandate to the Ninth Circuit. The Ninth Circuit will probably take a day or two on this to issue an order lifting the stay and dismissing the appeal. And when the stay is lifted, Prop 8 can no longer be enforced.
And Governor Brown has already said everybody's got to do it. It's not just the two couples that can get married, everybody can get
And
married.
it's not just those two counties.
Right.
With the
He's
district.
saying-
He can
say that, but there are going to be lawsuits.
There'll be lawsuits for sure.
And
Again,
what are the-
So they're going to hold this up because the people who don't have standing in
Right.
federal court, the Prop 8 proponents, do have standing in state court.
Okay.
So it's kind of a mess because here we are again having a delay. Every day that passes, gay and lesbian couples in California are being deprived the ability to marry. This is just going on, and it's going on.
So you think
and
it'll
on
be
and on.
delayed again?
Well, but why couldn't
Not in Alameda and Los Angeles counties.
But that's so peculiar.
Because those clerks, yeah, but Los Angeles County, that takes in a lot of territory. And people can come from anywhere to Los Angeles County and get married, right? You don't have
Well,
to
that's true.
reside in the
That would
county.
be interesting. That
And
it's
if
good
they,
for Oakland.
Yeah.
well, just
Yeah,
saying, I
Oakland,
mean,
Alameda County.
one would hope that, you know, if they make these appeals, that they're not given a stay of the thing.
One
Right?
would hope- that's correct.
Right.
Couldn't
Yes.
that- and
It
then the
could go
marriages
into
could go
effect.
forward.
Yeah.
Absolutely.
Because you don't have a good chance of succeeding.
And it's interesting that the Prop 8 proponents who today were basically declared non-entities. The U.S. Supreme Court says this group doesn't really exist. Right?
For federal purposes.
Right, for federal purposes, they don't have any right to be in court, are proclaiming a great victory today because the Ninth Circuit opinion that they didn't like has now been overruled. But they have no place in the federal system. But they could mess things up or delay things in the state system for a while.
And as Andy says, depending on whether or not the district court decision is further stayed pending those cases or not.
And I don't think that a state court judge has authority to stay a federal district court decision. They would have to go to a federal court, wouldn't they?
Well, they would have. well,
Wouldn't
if
the
they had to go to-
supremacy clause rule
No,
that out?
if they had
Take
to go to-
10 more years.
If they had to go, no, if they had to go to federal court, that's great. Then there's no one that can go in if it's
Right.
federal court.
Now, wasn't Von Walker's decision interpreted when it came down as being so comprehensive and broad that it might apply beyond California or be a model for beyond California?
Well, there's lots of good stuff in there that people can cite and quote, but the problem is a trial court decision is not binding precedent on anyone.
Okay, so it wouldn't extend, it
It's a
wouldn't be
persuasive
easily extended to the rest of the Ninth Circuit?
People
or-
can cite it. You know, the problem is the Ninth Circuit decision gets vacated on grounds that the
Right.
Ninth Circuit didn't have jurisdiction over the appeal.
Right.
So everything the Ninth Circuit said is no longer citable as precedent in
Well,
the
they
Ninth
were
Circuit.
very narrow
Now, we have
anyway.
2 cases pending in the Ninth Circuit.
Yeah.
You know, we have the Nevada case and the
Oh,
Hawaii
yes,
case.
yes.
And so they're writing on a fresh sheet again. But, you know, you can't really ignore what 2 out of 3 judges on the 3-judge panel said, because they're going to come up before the same Ninth Circuit.
Now, am I crazy to think, and feel free to say yes, that that it's a little poignant to have these people denied standing? Does that sort of narrow our access to jurisprudence if standing is read narrowly? I sort of think, well, you know, I think it's good to have more people have standing and go ahead and argue these things out in
Well,
court.
you know, this is a long-term trend in the federal courts.
Yeah.
The courts have been contracting standing for decades now, and it's part of the general idea of keeping people out of court.
But
Is that a good thing or a bad
It's been
thing?
the people who we tend to have voting against us
Yeah.
who are the ones limiting standing.
Right.
So
Well, that's what
why
worries
you,
me.
No, I think you're right to be worried.
Right. Like citizens who see an environmental problem in
Yeah,
their community
exactly.
and they want to run to court, and the court says, well, you don't have standing, you have no different interest than anyone else.
It's sort of like this, the employment cases, Vance and Nassar, where they really limited people's
Yeah.
ability to claim discrimination.
And we should talk about them briefly, because I see that we do have a little more time.
Yeah.
And I think we pretty much exhausted the Prop 8 for now.
Well, go ahead. We'll throw in anything
So
we
there are
think is
several other
appropriate.
Supreme Court decisions that came out over the past few days that people should be aware of. One is the USAID versus Open Society case from last week involving restrictions that Congress put on money appropriated to fight HIV overseas.
Oh, this is the great bright light.
this was
They said
terrific.
the restriction was two things, that you can't use any of this money to promote prostitution, but B, you got to support the government's position against prostitution, and that's what the court overruled.
Right.
Yes, as irrelevant to the grants being made.
And a violation of the First Amendment.
Yeah.
Right. Several non-governmental organizations that do AIDS prevention work overseas said, we're going to be in a tight spot in dealing with some of the people we have to deal with if we have to have a formal policy against prostitution, and we're not allowed, for example, to conduct activities in showing prostitutes how to have sex safely, or distributing prophylactics and things like that. It's going to crimp us, it's going to harm us with some organizations. And in fact, Congress even recognized this difficulty because they exempted certain international bodies from this rule. So like federal money going to the World Health Organization can say anything they want about prostitution and they're not disqualified. But if it goes to any of these non-governmental organizations. So Chief Justice Roberts, in a very strong First Amendment decision, said that this is like compelled political speech. It's not appropriate condition to put on federal money. So that's our one real bright light among a stream of awful decisions over the past 2 weeks.
Almost all 5-4.
Almost all, an incredible run of
same.
5-4 decisions. That one wasn't. That one was like 7-2.
Yep.
But we had two decisions this week on Monday involving Title VII of the Civil Rights Act, which bans discrimination based on race, sex, religion, national origin. One of them involving harassment cases, and the other one involving retaliation cases. Retaliation cases are cases where an employee raises a non-discrimination issue of some sort and then suffers an adverse consequence. And this was the Nassar case. Dr. Nassar raised discrimination claims at the medical school where he was on faculty. And eventually he claims he was constructively discharged. And he applied to be a doctor at the affiliated hospital. And the head of the medical school pressured the hospital not to hire him. And he said that was retaliation. And the head of the medical school came back and said, well, that isn't retaliation. That's because we have an operating agreement with the hospital under which they can only hire members of the faculty. And he's not on the faculty anymore. That's a non-discriminatory reason for not hiring him. So this was treated as a mixed motive case. That is, one motivation was retaliation. The other motivation was their operating agreement under which you can only hire members of the faculty. And so the Supreme Court said, well, that means you have to dismiss his retaliation case because they had a non-discriminatory reason. And the court had issued similar decision way back in the 1980s in the Price Waterhouse case, 1989, which Congress overruled by amending Title VII to provide that in a mixed motive case, the plaintiff wins, but the remedy is limited if the defendant can show a non-discriminatory motivation. But the plaintiff can still win an injunctive relief, can still win attorney's fees. But the Supreme Court, in a bit of sleight of hand in terms of statutory interpretation, said, oh, that fix that Congress put in the statute, that only applies to status discrimination cases. It doesn't apply to retaliation cases. And I'm worried about that because of its impact on ENDA.
The Employment Non-Discrimination Act, pending for the last 20 years.
Which would outlaw discrimination based on sexual orientation and gender identity. ENDA's non-discrimination provision is worded word for word like Title VII's non-discrimination provision. And ENDA does not have any language like the fix that Congress put in Title VII to overrule that Price Waterhouse case. So what we got to do is the people in charge of drafting on ENDA have to go back and take that amendment and adapt it to ENDA. And then the other case.
It's not like we're on the verge
right.
of passing it.
Right. It's not. We got time because the House is never going to even take it up as long as the Republicans control the House. So we have time to redraft on that. And then the other case was the harassment. And this is a biggie because one of the biggest issues for gay employees is workplace harassment.
Yes.
And sometimes it's harassment by supervisors, sometimes it's harassment by coworkers. What about a coworker who has some authority to direct people? You know, is not strictly speaking, a supervisor with, authority to hire and fire and promote and demote and stuff like that, but has authority to direct someone's work. If you're harassed by someone like that, should the employer be liable?
Well, why
The
wouldn't
court said no.
Why
The court said
wouldn't-
no.
Why wouldn't the employer be liable if anyone harassed you?
Well, the way the Supreme Court has interpreted this, and Title VII itself doesn't even mention harassment, so this is all statutory interpretation of stuff that isn't even written in the statute. They said harassment that is discriminatory and that affects terms and conditions of someone's employment may be discrimination under Title VII. And an
Because it
employer,
could
so
affect their
if someone's
advancement or
terms or conditions of employment, like their pay or their rank or benefits, something like that, if that's affected, then the employer is automatically responsible. But if it's a supervisor who's an agent of the employer and the supervisor harasses, the employer may also be responsible because the supervisor is their agent. But they said these low-level people who just direct people's work but don't affect tangible employment benefits and things, they say the employer is not automatically liable. You have to show that the employer was negligent.
And again, the
So are
odds
you allowed to punch out the coworker?
Well, punching out, then that brings in criminal law and tort law. And Larry's a tort person, he can tell you about punching out.
You get my point.
But the point is that we need to have a definition of what kinds of attributes someone has to have for the employer to be responsible. And, maybe Congress will agree with the court and not do anything here.
I would think coworker.
But we
would
might
be
want to
a-
put something in ENDA about that, because harassment by coworkers is a big issue under Title VII.
Absolutely.
Under ENDA.
Here's another question that's come up immediately in the wake of the DOMA decision. Someone put out a statement that said, or an analysis that said, this is going to present a problem because with the federal government not recognizing same-sex marriages, we've been able to skate under the radar a little on benefits questions. And if the federal government is now going to recognize both partners in the relationship and their incomes, this is going to deprive a lot of people of benefits
well,
now.
rights and responsibilities.
Well,
Exactly,
In
but-
situations where household income is taken into account on whether you qualify for welfare or other kinds of benefits, yes.
HIV benefits, whatever.
In other words, we've been pushing for equality. Now we're going to get equality.
Yeah.
And for some of us, with two-income families, we're going to be booted up into higher federal tax brackets and owe thousands of dollars more.
Mm-hmm.
And there are some
my partner and I. among
Well,
others.
I don't know if you're one of these couples, but some couples out there are looking to recover some
Right.
taxes from from past years,
Right.
as Edie Windsor is
They
going
already
to.
have refund petitions on file, anticipating this opinion.
Statute of limitations, though?
Yeah, there's a period of how far back you can go in terms of
3
the
or
statute of
5
limitations.
years or something.
But the point is, if we want equality, we have to take the good and the bad.
And people who are considering getting married need to take
Right.
all this into consideration,
Think about that marriage penalty on taxes.
Now,
among other things.
and Larry, you're a little closer to the Ninth Circuit geographically,
yes.
Do you have any sense of these Hawaii and Nevada cases and where they're going to go? And
These
I'm
are
intrigued. I mean-
challenging the constitutional amendments.
I mean,
State
I
constitution.
think it's interesting what you said, Art, about what happens to the Ninth Circuit opinion, because you suggested that they might look at it, but it's sort of a nullity. So I don't know what they can. It's there. I mean, it's it's a great opinion.
They can't cite it, they can't
right.
quote it,
So
but they can paraphrase
and
it.
it's likely to be a different panel of 3 judges
Could be.
who
it
would
could
be
completely
considering it.
different.
I want Reinhardt on that panel
Right.
for both of those cases.
But it'll be, this issue's just, it's far from over. I mean, that's one of the lessons from today, is that there's so much more ahead in terms of
How long
till what?
till
Everyone can marry everywhere?
Peace and understanding?
Yeah,
or
no,
what?
no. For this to be resolved in this
Well,
country.
eventually, and Scalia, Scalia is really far-sighted on this kind of stuff when he's predicting things in his opinions.
Yes.
10 years ago in Lawrence, he said this is opening up the door to same-sex marriage.
Yeah.
Well, at the time of Lawrence, no same-sex couples could get married in the U.S.
True.
Within months of Lawrence, the Massachusetts Supreme Court ruled in favor of same-sex marriage.
Yeah.
Now we have 12 states. As soon as Prop 8 is finally blocked in California. We'll have 13 states.
Plus the District of Columbia.
Plus the District of Columbia, and Illinois might come up for another vote this summer. We might get Illinois.
New Jersey.
I don't
their
think-
court
New Jersey, there's a court case in New Jersey, and Lambda Legal, which is doing the court case in New Jersey, put out a presser right after the court came out. They said, we're going to ramp up that lawsuit in New Jersey now,
Send us money.
you know.
Yeah,
So,
that for sure. They
you
say
know, and
that.
there'll be lawsuits in other states. New Mexico, I think there's a lawsuit
Yeah.
now.
And when's Alabama going to be letting
And Mississippi.
Alabama will be among the last.
Well, don't you read that a little for me, because people are saying, you know, why didn't they go ahead and do marriage for 50 states? Why do we have to wait? They did it with interracial couples. Why? And I've tried to
but there's-
explain, because
well-
they've gotten
well,
cautious after Roe.
Well, one of the things with the Supreme Court is they have a general rule, which is not always observed, but a general rule is don't decide contentious, hotly argued constitutional questions if you can dispose of the case procedurally or
If you can
by
deny
statutory
standing.
interpretation or
Well,
some other
no.
way.
Yeah.
And so they look at the Prop 8 case and they say, do we really want to decide this year whether same-sex couples have a right under the 14th Amendment? And those of the Supreme Court who are actually looking at what's going on in the country are saying, okay, you know, state by state, 1 state, 2 states, 4 states, 8 states, we're up to 12 states. With the Prop 8 case, it's going to be 13 states. Things are moving. There's no rush for us to decide this. Things are moving.
Except if you live in Alabama.
And there are all these cases still pending out there in the lower courts. The issue is going to come back to us. And Scalia said as much. He said, that, you know, within a few years, we'll be deciding whether the 14th Amendment requires it.
And it depends on who's on the court at that point.
Right.
And it's and these were 5-4
Right.
decisions. So we are in peril. People better vote, and they better, you know, vote to elect another
Who is in the Senate?
Democratic president.
Who is elected to the Senate next year is very important,
Extremely.
because the Senate ratifies judges.
And
Who
it's-
was
it is-
elected president in 2016?
It is really hard to get. Recently in Sacramento, there was a new federal magistrate sworn in, and I went to her swearing in. It was deeply moving. She is maybe the most important and interesting thing, a federal public defender. So that's almost unheard of getting to the
Wow.
court. She is a legally married lesbian with triplets. And one of my friends who had clerked in that same court in the mid-'80s happened to be back, and we were talking, and I said, in 1985, when we were both here, when I moved to Sacramento, if I had told you we would have an African-American president and a married lesbian with triplets was being sworn in as a judge in this court, you would have had me institutionalized, right?
Exactly.
So we don't know, you know, I would have told you in the 1990s, no, gay people would never be getting married in my lifetime.
Right.
Right.
So we don't know.
But,
It's kind of
you know,
amazing.
but for a lot of the fixes, for the bad decisions that you're talking about, voting rights and affirmative action, all these kinds of things,
We need
it's
another
dependent
Democratic judge on the court.
on the Congress also to fix these things.
Right.
And we're going to have a Republican House until state legislatures are controlled by Democrats who put in Republican districts, Democratic districts, you know, that kind of stuff.
The possibility of which has been lowered by the Voting Rights Act
And we should
decision.
mention that decision from yesterday, which Justice Ginsburg pointed out in her dissent. Chief Justice Roberts really misrepresented the record before Congress when it extended the Voting Rights Act
Right.
in his decision. And I'm afraid that the media is not necessarily picking up that issue, that Congress was presented with lots of evidence that many jurisdictions, and especially the handful of states specifically covered by the preclearance requirement under the Voting Rights Act, of trying to figure out ways to suppress minority voting. So there is still a need for that. That's a prophylactic provision.
They have jumped out of the gate to impose laws that will restrict voting one day after that decision.
Right. Texas immediately announced that our new voter ID law, which was on hold because of the preclearance thing, is now in effect.
And
Oh,
Yes, there's no
New
more
York
police-
is celebrating they can use lever
that's
machines
right.
again.
Yes,
I'm
New
in
York
favor of
City no
that.
longer has to get preclearance.
Yeah,
But you
well-
all remind us
I
that,
always like the lever machines.
Exactly.
while we have much to celebrate today,
Yes.
Yeah.
and we do, I think we should celebrate the victory for the LGBT community, that this was a very bad week for workers and for people of color. And so
Which a lot of our community is as
Right.
well.
Exactly.
The affirmative
So-
action case, too.
Exactly. So
which
it's
was,
not, we have a lot of work ahead across the board.
Absolutely.
Well, in terms of work ahead, there are some weird things that were announced today. The ACLU announced today that it is embarking on a, wait a second.
They got a 4-year plan.
4-year plan, $10 million. They have hired Steve Schmidt, who's turned into a really good guy, but Republican strategist for John McCain, and Jimmy LaSalvia, who ran Go Proud.
Oh my God.
The hideously right-wing 3 members LGBT group.
If it's 3 members, it can't be LGBT.
That's true. But they're hiring people on to these people on to try to penetrate those states that are more Republican or right-wing. And that's going to be just a mind blower to see Jimmy LaSalvia working for the ACLU.
Well, you know, one of the things that strikes me as an interesting new development, we now have 3 Republican senators who are in favor of same-sex marriage.
Mark Kirk, Susan
Kirk,
Collins.
and Lisa Murkowski.
Yes.
And also Portman, right?
Oh, Portman, maybe not one
Not
of those
Collins
others.
yet.
Not
Collins hasn't gotten the full
you're
distance
right.
yet. But we got 3. That's an opening wedge.
Yeah.
Maybe
one of them's closeted.
Yeah, maybe some way can. Well, we shouldn't say that on the air. Maybe
We do all the time. You
maybe
know.
some way should be found to widen that wedge and get more Republicans to be.
Well, this is a
that's
very
what they're
conservative
working
issue
for.
for Republicans. It's an easy one for them to
Yes.
support. They got gay
Yes.
friends. You want to get
Yes.
married. You want to
Andrew
take
Sullivan's been telling
responsibility.
them this for years.
You know, I worry about what's
Exactly.
going to happen to people who are more on the fringes of our community.
Oh, you
Right.
should. I mean, all the people want are to become Boy Scouts, to join the military and get married. We've become so square, it's kind of a little embarrassing sometimes, right? What about
Yes.
sex orgies? You remember the good old days?
Yes.
Yes.
Yeah, exactly.
Freedom.
Yeah,
I do.
exactly.
I
don't remember it
Country's
anymore.
going to hell in a handbag.
No, but you don't even hear the movement defending sexual freedom anymore, basically.
Or marriage equivalence, right? That there's this frenzy about promoting marriage
Right.
when we're pushing everyone into this structure and domestic partnerships, and that option may just
We still have it in New
disappear.
York City.
Yeah.
It is still an option here, and most people who take advantage of it are straight.
And I will just throw out my eternal question when this comes up. What rights do you want to give up from marriage to have domestic partners? Where is the distinction?
Oh, well, I mean, people don't want to go the whole hog. They don't want to be part of a patriarchal institution or a historically patriarchal institution.
They don't
In
want to have
what-
to go to the
you
divorce
just
courts
brought-
if things don't
Right.
work out. You know.
I'm not saying people shouldn't be allowed to get married. I'll
Yes.
allow it.
This is
I'm a very liberal.
Thank you,
I'm
Professor.
very
Very
open-minded
big-
that way.
What
yeah.
we
So-
need is family diversity
Yeah.
that reflects the numerous different ways that people construct their
we
families.
need universal health coverage.
Yes.
We
Right.
need
Coverage should not be tied to marital status.
Yeah, we
or
to
need an
jobs.
end to violence. We need a
Economic
lot
justice.
of things. Yes,
Big-
that too.
That's a big thing.
Right.
An end to gender discrimination. Let's
And-
go on.
and-
the more we legalize same-sex marriage, by the way, the more we help transsexual and transgender people who are caught often in Texas in different counties.
Right.
They have different rules for transsexual people marrying. In one county, you can only marry one sex, and the other county, you can marry the other sex.
Yeah, and once we have a law that says the marriage law is gender neutral, it doesn't matter the gender of the
Exactly.
spouse.
It would be
Well,
Exactly.
we are down to our last minute, so this is going to be a very happy Christopher Street Liberation Day this weekend
Oh
in New
my
York and in
God!
San Francisco.
All over the country. All over the country.
We will see you out there.
Any predictions on any Supreme Court justices disappearing in the near
No.
future?
I don't think so.
No.
I don't think so. Justice Ginsburg has pretty much committed that she's going to stay until maybe a year before the end of.
She must be really
this term.
worried about someone appointing a replacement.
Yeah, but I'd like to see Scalia retire because
Wouldn't that be nice?
he's the senior Republican on the court.
Oh,
so.
okay. Well, thank you both for coming in. Art Leonard, Larry Levine, law professors and superb human beings.
I'm going to have to DVR this and watch this show so I can get everything that you said.
I'm going home to watch it.
Read
Read
the
the
opinions.
decisions. Yeah, the opinions, yes.
Wonderful, easy to download from the court's website.
Good luck.
Thank you.
There
And
actually, Scalia's dissent is very amusing. You
And,
will you'll laugh out loud at many points.
on that note, we will see you all next week. Thank you very much.
Bye-bye.
Bye.
Bye bye.